So raise your hand if you have a case today. What's your name?
T. Dorsey.
Say it again.
T. Dorsey.
All right. In the blue.
You're right.
All right, and you do? Say it again. Okay.
Lyens.
Well, Mr. Lyens, and what about way and back? Okay. All right, so Erica Wright, want to come up to the podium? Mr. Malaro, I have Erica White. So, Mr. Sneed, I have Mr. Sneed. So this is in the matter of the people of the state of Michigan versus Erica Lynn Wright, file number 25-22217FH. I have Mr. Malaro, you're appearing on behalf of Matthew Murphy today.
That is correct, Judge.
And then I have Isaac Sneed appearing on behalf of the people. So I have a letter dated September 15th that Ms. Wright has not done a drug screen since August 15. She claims her doctor told her she couldn't leave the house. She did provide doctor documentation on September 5, but it doesn't mention travel restrictions. So I'm going to have her have a seat and I'm gonna have her tested today. So you're just gonna have a seat in the courtroom. Don't leave the courtroom. And let me get Mr. Coast here to set up a drug screen. Miss Adams, could you call Mr. Coast?
Yes, Judge.
Okay, thank you. Okay, so. Mr. Malaro, I do believe that's all I had with you today.
Judge, I think I have an 11 o'clock motion hearing with you, but I'll be over
You
there.
do? I have Miss Wright though, and it'll take a little bit of time to have a test done. So I don't know if you need to, if you want to wait or you want to bop over to Judge Olsavers.
Yeah, I'll go over to the other judge's courtroom judge, and then I'll be back.
Okay. All right. Thank you. All right. Mr. Love will pick up too.
Yes.
You got arrested.
Last night.
Okay.
Hi, this is Judge Anselone. I am ready on Dylan Scott and Robert Love whenever you are.
Okay, we are getting a couple rooms ready upstairs. So give us just a couple more minutes and then we'll have them in for you.
All right. Thank you so much.
Yeah, you're welcome back. Bye.
All right, Mr. Likens. Oh my gosh. All right, Mr. Likens, you want to come on up. All right, this is in the matter of the people of the state of Michigan versus Benjamin Lyens. We have file number 23-21610 FH, 23-21611 FH, and 24-21736 FH. So we are here on a violation of probation show cause that was filed on September 16th. And it alleges that on August 1 of 24, you were ordered to comply and complete the Lenawee County Recovery Court. They're alleging that you failed to do so, and that on September 9th, when ordered to complete 25 hours of community service until you obtain legitimate, verifiable tax-paying employment, you refused and you said you would not comply with that directive. And then they also allege that you violated your probation in that you were ordered to obtain legitimate employment of 30 hours a week or more. And you have failed to do so. On August 9th, when directed he could not work for himself due to not paying taxes or being verifiable, and that he must obtain legitimate employment, he refused to do so. So, Mr. Lyens, you're on probation for several files. So if you were to plead guilty or be found guilty, you could be facing up to 10 years in prison on file number 23-21610 FH, and on file number 23-21611 FH, you could be facing up to 4 years in prison. And on file number 24-21736 FH, you could be facing up to 4 years in prison. So, Mr. Lyens, you do have the right to have an attorney represent you on this and all subsequent hearings. Can't afford hire one, we will appoint one at public expense. Would you like an attorney appointed?
Yes, Your Honor, please.
All right, so we will appoint an attorney at public expense, and it might, because it's a Wednesday morning, Miss Adams, did you send out tomorrow's docket yet?
No, Judge, not yet.
Do I have time to have this set over to tomorrow morning at 8?
You have. You have 8 sentencings and a 9 o'clock evidentiary.
Okay, I'm going to have you just have a seat and we'll see if we can get someone to talk to this morning.
Okay, thank you.
You're welcome.
You have appointments tomorrow morning. I don't.
Yeah, well, it might be a while, but just hang out with us, all right?
Thank you.
You're welcome. Okay. Jail here. Who's the friend of the court show cause, Miss Adams?
That is Dylan Scott.
Oh, I just have him down for felony file, so there's a family file too. All right. All right, sorry about that. I see. Okay. I have no defense attorneys right now. I have prosecutors, but I'm waiting on defense attorneys. All right, I have a gentleman in jail Zoom 5. What is your name, please?
Dylan Scott.
All right, thank you. Let me grab your file. So we have 2 files. This is in the matter of the people of the state of Michigan versus Dylan Matthew Scott, file number 22-20799 FH. Mr. Scott, on that file, there is a bench warrant. there was a request and warrant for probation violation that was filed on August 9, which alleges that you failed to report as instructed on or about August 5 of 2022 or any time thereafter. So on that case, that is a non-technical violation of probation, and you could be facing up to 4 years in prison for failure to appear on that one. And then on file number 19-46552DS, that is a failure to pay child support show cause, which alleges that the balance of your child support today is $7,324.03 or 2 cents, and that you failed to appear for a show cause back on March 6th of 2023, and a warrant was issued for your arrest and bond was set in the amount of $2,500. So on this file, you're facing a maximum penalty of up to 90 days in jail on the failure to pay child support and 93 days on the contempt court for failure to appear. Do you understand that, Mr. Scott?
Yes, ma'am.
Now, Mr. Scott, you do have the right to have an attorney represent you here today on this case, as well as any other subsequent hearings. Would you like an attorney appointed to represent you?
Yes, ma'am.
All right, so Mr. Scott, you are just gonna hang out with us for a moment, and so, actually, I'm gonna let you go, and they'll bring you back later when the public defender has time to meet with you, all right?
Yes, ma'am.
All right,
So-
tell them you're all set, and I'll call for you later.
Yes, ma'am.
Thank you. All right, so Ms. Cam, it'll probably be a few hours.
Okay, thank you, Your Honor.
Thank you.
You think she's all with your phone?
And somebody had just admitted on an iPhone. Could you unmute your device, please?
Hello,
Hi, what is your name, please?
Zachary Dillard.
All right, Mr. Dillard, I am going to change your screen name. And who is your attorney?
Miss Underwood.
All right, so I am going to put her initials after your name. She is in front of Judge Olsaver right now. So I'm gonna pop you in the waiting room. When she gets here, I'll bring you back in, okay?
All right, sounds good.
Thank you. I have someone I just admitted on a, who's calling in from a phone. Can I ask your name, please?
Oscar Hernandez.
All right, can you say that again, please?
Oscar Hernandez.
Okay, thank you. And all right, you're represented by Miss Underwood. So, sir, I'm gonna change the name that shows up on my screen so I don't lose you. And do you go by Hernandez Ramirez or just Hernandez?
Hernandez Ramirez. Yeah, that's right.
Let me make sure I have that right. All right, so I'm changing your screen name, and Rhonda Underwood is in front of the judge next door right now. And as soon as she is done, she'll be back, and then I'll bring you back in, okay?
Okay.
All right, thank you.
Thank
Oh, yeah. Thank you. All right, Jill. All right, Mr. Coast, were you able to test Miss Wright or have someone test her?
Yes, Judge. Sarah Teskey actually performed a test. Miss Wright was positive for both THC and cocaine.
All right. All right. All right, so it'll be a little bit, so just stay here, okay? Mr. Love, good morning.
Morning.
All right, Let me get Miss Underwood in. Good morning, Miss Underwood. I'll be with you in one moment. So, Mr. Love, we are here in the matter of Jessica Steiner Zahender versus Robert Love Jr., file number 25-52342 PP. So, Mr. Love, I have received a complaint for violation of a PPO. Mr. Officer Castleberry from the APD, Adrian Police Department, alleges that there's valid PPO in place that prohibits you from entry onto the premises, and that it's alleged that on September 17th at 3:05 a.m. that you were living at the residence of 820 Mulberry Street. The personal protection order was entered on January 8th of 2025. And I do show that you were served with a copy of it on April 13 of 2025 and acknowledge receipt of that. So Mr. Love, failure to abide with a personal protection order can result in up to 93 days in jail. So let's talk about this, Mr. Love. So Ms. Zahender, Steiner Zahender, back in February, did file a motion to terminate a PPO, but nobody showed up. She didn't come in and she didn't make the motion in front of the court. So I can't grant them just because someone filed paperwork. She received notice of hearing to appear, and she failed to appear that day. So that's my problem. So here's what I'm going to do. First, I'm going to say you have a right to have a court-appointed attorney. So if you would like a court-appointed attorney, I can appoint you one at public expense. If you don't and you wish to hire someone, we can adjourn it for that. But Mr. Love, what I think I want to do at this point is try to reach her to see if I can get her to Zoom in. So I'm looking through the paperwork. And of course, I don't. Miss Adams, do you think you could find out if the clerk's office has a telephone number for her? I know, oh, Miss Adams, I do have a phone number for her. So Mr. Love, just hang tight for a moment and I'm gonna have my staff reach out and call her. Miss Adams, it's on the initial petition that was filed, the initial petition. All right, so Mr. Love, just hang tight for a moment. All right, Miss Underwood, let's see. I have Ashley Messer from the AG's office. So I have Mr. Hernandez Ramirez. So let me grab his file. And Miss Underwood, I don't know if you can do this, but if you want to text Mr. Malaro, if he is free for a minute to pop back in, we could take care of his other one. I only had one with him, and we could take care of that really quick when he's not busy. The judge will say. All right, Mr. Hernandez Ramirez, can you hear me?
Yes.
Okay. This is in the matter of the people of the state of Michigan versus Oscar Hernandez Ramirez, file number 24-21965FH. I have Rhonda Underwood appearing on behalf of Mr. Hernandez Ramirez, and I have Ashley Messer, M-E-S-S-E-R, appearing on behalf of the AG's office. Ms. Messer, what is your P number, please?
Your Honor, it is 76062.
All right, thank you. So Mr. Hernandez Ramirez is here today on a pretrial. Ms. Underwood, how would you like to proceed today?
Your Honor, I've spoken with the AG's office. I've also spoken with Mr. Ramirez. Mr. Ramirez is making payments. I don't believe the Attorney General's office would have any objection to a 69 to 90 day adjournment to keep building Mr. Hernandez Ramirez's payment history, Your Honor.
All right. All right, is that correct, Ms. Messer?
It is, Your Honor. The defendant has made some significant headway towards this arrearage, so the people have no objection.
All right, excellent. So Mr. Hernandez Ramirez, I commend you for the effort. I am going to set this out to December 10 at 8:30 in the morning, December 10 at 8:30 in the morning. Ms. Underwood will do the stipend. You're not available?
No, I was going to say I'm happy to do the stip and order with Ms. Messer's permission.
I was saying, I don't think you're allowed to get vacation. So Ms. Messer, can she sign your name with permission?
Absolutely, Your Honor.
All right. So Mr. Hernandez Ramirez, we'll see you back on December 10 at 8:30 in the morning, okay?
Okay, that's fine.
All right. Thank you so much.
All right, thank you.
Ms. Messer, on a waiver of arraignment was filed on Nathan Lawrence. And let's see. And now I'm going to take care of Zachary Dillard, and that should be all you had this morning, I think, Ms. Messer.
That's correct, Your Honor. Thank you so much.
All right, Mr. Dillard, go ahead and unmute your device, please. Oh. Okay, this is in the matter of the people of the state of Michigan versus Zachary Ryan Dillard. File number 25-22291FH. I have Rhonda Underwood appearing on behalf of Zachary Dillard, and I have Ashley Messer appearing on behalf of the AG's office. This is the date and time set for a pretrial conference. Ms. Underwood, how would you like to proceed today?
Thank you, Your Honor. Again, I've spoken with my client and the AG's office. Mr. Dillard is making payments. They would again have, I don't believe, have any objection to the same distance of adjournment, Your Honor.
Is that correct, Ms. Messer?
It is, Your Honor. The defendant did post that $1,000 bond that has been applied to the front of the court and against the arrearage, and he is making consistent payments and has been since his release in June. So I have no objection.
All right, excellent. So good job, Mr. Dillard. Keep up the good work. I'm going to adjourn this to December 10 at 8:30 in the morning, December 10 at 8:30 in the morning. Thank you, Mr. Dillard.
Thank you.
All
I'll
right.
do the stip and order, Your Honor.
Yes, ma'am. All right. I think every case I have is yours, Ms. Underwood, this morning, but let me double check.
Judge,
Yes.
I only could reach the voicemail, so I did leave the Zoom ID number for Jessica. I don't know if she'll get it or not.
There were 2 phone numbers. Did you see that on the
Yeah.
initial petition? Yeah.
Yes, the first one's just automated.
Okay. So we'll give her a couple minutes and then I'll call your case again, Mr. Love. All right. Ms. Underwood, I have quite a few pickups and I'll just move them to the end of the docket. All right, Ms. Heimerdinger, if you can start your video and your audio for me, please. All right, so this is in the matter of the people of the state of Michigan versus Jamie Marie Heimerdinger, file number 21-20407FH. Matthew Murphy represents Ms. Heimerdinger, but I believe Ms. Underwood, you're appearing today for Mr. Murphy.
I believe this was a violation of probation, Your Honor. Hang on.
Maybe, I just had your name down. All right, let me double check.
But if
All
Mr.
right,
Murphy's
this is
handling
a
it,
violation of probation pretrial, so you were
Right.
already appointed to represent her.
right. You said Mr. Murphy, so I was confused. Okay,
Yeah, he was the original attorney, sorry.
okay.
So, Ms. Underwood, how would you like to proceed today?
Well, I'm going to have to talk to my client, Your Honor. I know the last time we were here, she was just hours after giving birth, so.
Okay. All right, so I'm gonna open up some breakout rooms. And so Ms. Heimerdinger and Ms. Underwood, go ahead and join that breakout room. All right, we'll give them a moment to speak. Mr. Brandt. Let me bring in Calvin Isom. All right, Mr. Isom, if you could start your video and your audio, please. All right, excellent. So this is in the matter of the people of the state of Michigan versus Kelvin Tyler Isom, I'm sorry, 25-22248FH. I have Alfred P. Brandt, P38586, appearing on behalf of the defendant, and I have Alexander Bayonetto. I have Mr. Bayonetto as prosecutor on this one, and he's here. I thought he was here, but now he's not here. So I guess, Mr. Sneed, you need to log back on.
He's in the waiting room, Your Honor.
Yeah, he left and he came back, so let me let him in. All right, so, and I have Alexander Bayonetto appearing on behalf of the people. So this is the date and time. I believe this is the 5th pretrial or the 4th pretrial. So, Mr. Brandt, how would you like to proceed today with Mr. Isom?
Thank you, Your Honor. Your Honor, Mr. Bayonetto forwarded to me a proposed plea agreement. I met with my client and his mother last week. We are in agreement with that. So here's what, from my position, we need to do. I need to get to the court to sign plea agreement. And the difficulty is this is a no contest plea. If you look at the nature of the charge, there is an injury, there is a pending lawsuit. The basis for a no contest.
Is he pleading today or no?
Oh, no, we'll set it for another day,
Okay.
Your Honor. I need to get you the police report, and because it's a accident, there's an initial report.
So, Mr. Brandt, hold on a second, Mr. Brandt. I don't place factual basis on the record. I expect either the defense attorney or the prosecutor to. So that's fine. We allow signing DocuSign for documents, but that's fine. And then Mr. Brandt also needed an advice of rights filled out by your client. So I can set this over to October 1 at 8:30 for a plea if you'd like.
Your Honor, I think we will be in person for that. Let me make sure. Yep, I can be there. October 1 at 8:30?
Yes.
Yep, and I think we'll be there in person because of the nature of the charge.
Okay, so I'll set this over for a pretrial on October 1 at 8:30 in the morning. And then, Mr. Brandt, you can do the stipend order to adjourn, and Mr. Bayonetto, can you sign your name with permission?
He can, Your Honor. Yes, thank you.
Okay, excellent. Thank you. All right, you're all set then, Mr. Isom and Mr. Brandt. You have a good day.
Thank you, Your Honor.
All
Yeah, great day.
right. So Mr. Love, we have not received any contact information. So here's what I'm going to do, Mr. Love. I'm going to release you on a pair bond. And I'm going to set this for another day. But listen, I'm sure there might have been some confusion because she filed paperwork, but if you don't show up for the court date, I can't terminate the PPO. So I am going to mail out a notice to get in next week on her petition, okay? But that means you can't go back to that house until after that hearing, okay?
Yes, ma'am.
I was hoping we'd be able to reach her and she would pop in today, but we haven't been able to reach her. So I will mail out a notice of hearing. Miss Adams, could I get a date? Next week. I need like 10 minutes. Not at 8 AM though, because school drop-offs, I think, but I don't know.
11:30, September 25th.
All right, so I'm gonna set this over to September 25, which is a week from now. At what time? 11:30?
Yes.
So Mr. Love, find somewhere to stay till then. And then we'll mail out a notice of hearing for her, but your jail paperwork will have your notice on it and your date and time to be here, all right?
Yes, ma'am.
All right, so we'll see you back on September 25 at 11:30, and I'll release you on a PR bond. No contact though until we come back on that hearing, all right?
Thank you, Your Honor.
Thank you, Mr. Love. You have a good day. Or better day, a better day.
Yes.
Okay. All right, Miss Underwood, you are back. We'll bring Miss Heimerdinger back in. Did you text Mr. Malaro for me, Miss Underwood?
I will do
I
that,
see.
Your Honor.
See if he's busy. Let me go look at Judge Olsey's doing. Oh, Mr. Malaro's not even in front of him. He might be in a breakout room. I don't know. Now I know where all the jail rooms are though. Judge Olsey has them all. Okay. So we're back on the record with Miss Heimerdinger. Miss Underwood, how would you like to proceed?
I guess, Your Honor, I have conflicting information, so what I'm gonna do is set this for a hearing, Your Honor. And see and talk to Ms. Tusky.
All right, Miss Adams, I will need a hearing on this, please. A half hour.
Okay. Sorry, which case was it, Judge?
Heimerdinger.
Okay.
It's a BOP trial.
How far out do we need to go? Or we could...
At least, I think the only witness would be Miss Tusky, so probably at least 2 weeks from now.
October 7th at 8:30.
Miss Underwood, October 7 at 8:30 in the morning.
Thank you, Your Honor.
All right, and we will.
Can we do another day? That's our really, really busy report day.
Okay. Can we get a different date?
October 10th at 10:30.
Perfect.
October 10 at 10:30. That'll be in person. So we'll send out a notice of hearing for October 10 at 10:30 in person. All right, thank you, Ms. Heimerdinger.
Thank you. Have a good day.
You too. All right. In the matter of the people of the state of Michigan versus Julia Betts. File number 22-21100 FH, 23-21264 FH, and 23-21519 FH. Looks like this is down for a violation of probation pretrial. Miss Adams, is this a new one? I don't have paperwork. I have that she pled. I show she pled guilty on August 13. Is this a new one?
Let's see.
Because I have a notice of right to appellate review from August 13, but I don't have any paperwork on a new one.
Yeah, this got set on August 13th, and then looks like you ended up sentencing her, so I didn't remove it from the docket. Sorry about that.
No, it's okay. All right. Let's see. Rhonda Underwood, you represent Skyshine Tyndall, and I have Mr. Tyndall.
Yes, ma'am.
She already got sentenced back on August 13. We had it in our calendar too, because she was set for today for sentencing, but we ended up sentencing her that day, so that was our mistake. Sorry about that. Right. We got the tree. All right, Mr. Tyndall, if you'd like to start your video and your audio for me, please.
Yeah.
All right, good morning, Mr. Tyndall. So this is in the matter of the people of the state of Michigan versus Skyshine Tyndall. We have two files, 20-20027 FH and 22-20717 FC. So this is the date and time scheduled for a probation violation pretrial. I have Rhonda Underwood appearing on behalf of Mr. Tyndall. And Ms. Holly's here from the probation department. So Ms. Underwood, how would you like to proceed today with Mr. Tyndall?
Could I speak to Mr. Tyndall, please, Your Honor?
Yes, you can. So Mr. Tyndall, I am going to open up a breakout room. And I am going to assign the two of you to that breakout room to chat. And then I am just going to step off the bench for 1 minute. Just to get this pile of files out of the way. There.
Please rise for correspondence session. You may be seated.
Just be a minute. We're waiting on Miss Spade. Because sometimes I let her take a break too. Sometimes. I'm sorry. It's okay. Don't let it happen. Oh, I won't. Okay. All right, so I have Miss Spade back. And let her get set up.
Thank you.
All right, you ready?
Yes, Judge.
All right, so we are back on the record with Mr. Tyndall. Miss Underwood, how would you like to proceed?
Your Honor, if the court would be so kind as to grant Mr. Tyndall just 1 2-week adjournment, Your Honor, I believe we would have some major developments.
All right, my next available is October 8th.
That would be great, Your Honor.
October 8th at 8:30 in the morning. So we'll send the notice out, Mr. Tyndall. I'll see you back October 8th at 8:30 in the morning. Make sure you're reporting and in compliance with me.
There's a couple things. He needs to pay $150 a month at least to get this paid off in time. And I just looked it up and there is a warrant out because he didn't show up for a show cause in district court for a driving suspended license matter. So he needs to take care of that.
So Mr. Tyndall, it looks like there's something in district court. So it's a show cause for a driving with license suspended.
Yeah, he failed to appear, so there's a warrant.
Oh, I'll go check that out today. Damn.
Okay, so Mr. Tyndall, hold on, Mr. Tyndall. I think that's fairly easy to take care of. So I would probably, Miss Underwood, what would your advice be to Mr. Tyndall on that one?
Yeah, he should immediately take care of it. Yeah.
All right. So then I'll see you back October 8th at 8:30 in the morning, Mr. Tyndall. Thank you.
Thank you, Ms. Holly, for letting me know that too.
Yep.
You.
Yep.
All right. Thank
That's
you.
all I had with you, Judge.
All right. Thank you.
Yep.
All right. In the matter of the people of the state of Michigan versus William Jarrett Dillard, file number 23 dash, let me find them. Sorry. 23-21360 FC. This is a date time set for a violation of probation pretrial. Miss Underwood. No. Miss Underwood was appointed to represent Mr. Dillard. Miss Underwood, Mr. Dillard is not here.
He's in prison, Your Honor.
Yeah.
Well, that's why he's not here. Okay. So who's the PO on this?
That's me.
How long is he in prison for?
He got returned on parole. I don't know.
This is a consumption of alcohol. So Ms. Walsh, what do you want to do with this file?
I'd like to recommend prison since he has prison guidelines.
Okay, I just didn't know because he's there. So we'll have to do a writ. So I'm gonna set this out to October 8th at 8:30 in the morning, and my office will reach out to try to get a writ on him and get him back, all right?
Your Honor, this is the second time I would like to point that out, but okay.
Judge, there was a, excuse me, I'm sorry. There was a writ sent for today. I just don't think they responded.
Yeah, so we've done the writ. We just haven't got him yet, so we'll keep trying. All right, thank you.
Thank you.
Okay, so, hold on.
Is Mr. Dylan Scott your pickup, Judge?
Yes.
Okay.
He's asked for court appointed counsel, so I moved him to the end of the docket. All right, so Rhonda, the last one I have for you is in the matter of Teelan Dorsey. So Miss Dorsey, I need you to come sit over there. Miss Underwood represents Mr. Hayward. So where'd you go? Oh. come back over here. And then Mr. Hayward, I'm gonna need you to come have a seat right there. Mr. Mott, I'll take care of you next. All right, so this is in the matter of Thielen Dorsey versus Ephraim, right? Hayward, file number 25-52712 PP. Let's see, so we were here previously, and since then, on August 25, Ms. Dorsey, you filed a motion to terminate the PPO, is that correct?
Correct.
Want to raise your right hand? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
Okay, see that little microphone in front of you? Pull that towards you.
This?
Yep. And then repeat your response again.
Yes.
All right, can you state your full name for the record?
Tila Anastasia Dorsey.
Tila, I thought that was an N. I'm sorry.
You're okay.
So put your hand down. So, Ms. Dorsey, I show that you filed this on August 25, saying that you wanted to drop all the charges so that you can give a fresh start back in South Carolina. All right, so do you still wish to terminate the PPO?
Yes, ma'am.
Has anybody threatened you in any way to get you to terminate the PPO?
No, ma'am.
Has anyone promised you anything?
No, ma'am.
Are you under duress?
No.
All right, so I'm going to grant the request to terminate the personal protection order, and the court clerk shall file and complete the removal of entry from lien with the law enforcement agency named in the last order. And I'm signing this right now. It'll get processed. Miss Adams, because they're both here, would it be possible to get a signed copy of this for both of them so they can take it with them? Because it might take like 24 hours to go into lien. So, and then can you put down at the bottom that you served them? I'm going to dismiss the show cause. Okay. And then I'm going to dismiss. I'm going to dismiss the show cause. So both of you just have a seat in the courtroom. You can sit together if you want now. And then we'll get you a copy of both of those things. I wish you the best of luck.
Thank you.
Going forward, if you have problems, try counseling. Yes? Okay. Thank you both.
Thank you.
Here, Montalvo. All right, Miss Underwood, other than pickups, don't show you had anything else this morning. Is that correct?
Not in your courtroom, Your Honor.
All right, so if you want to go take care of Judge Olsaver's court, and then I can bring you back up on my pickups, all right?
Thank you.
All right, and if you can find Sam Malaro, send him to me.
Your Honor, it takes a better person than me to keep track of Mr. Malaro.
Thank you. I'll have Miss Adams text him. All right, so I also don't. All right, so Mr. Bowers, I'm waiting on Mr. Glazier. Did I set Calvin Isom over to 10-1 with Mr. Brandt?
Mr. Isom, yeah, 10-1, yes, Judge, in person.
Yeah. All right, Miss Johnson, you want to come on up to the podium? All right. Ms. DeMont, I'm assuming that you're in your new office that is under construction? No?
No, I'm in the Hillsdale County District Court Zoom room.
I was gonna see if I thought maybe you're in your basement. That's their Zoom room over there? Okay. All right, so this is in the matter of the people of the state of Michigan versus Noelle Marie Johnson, file number 25-28254FH. I have Isaac Sneed appearing on behalf of the people and Katerina Dumont appearing on behalf of Ms. Johnson. I have a letter dated September 15 from our pretrial services coordinator, Darren Coast, that states Ms. Johnson is doing a great job with her drug testing. She consistently tests. She is always negative. She has produced 36 straight negative tests, and he is okay with her going down to 1 time a week testing. So we will reduce her testing to 1 time a week through Mr. Coast. And so we're good on that. So Ms. Dumont, how do you wish to proceed today with Ms. Johnson?
Your Honor, we have an offer as charged with 7411. I confirmed that she did not previously have 7411 with the prosecution. So we signed advice of rights and the pretrial offer in the file along with a police report as we're requesting a no contest plea based on lack of recollection.
All right, and what is the plea offer?
As charged with 7411.
Is that a correct recitation of the plea, Mr. Sneed?
Yes, it is, Your Honor.
Is there any other terms? I don't have the agreement form, so it's okay. It's making its way to me, I'm sure. But were there any other agreements regarding sentencing or anything else?
No.
I think it is in the file. Sorry.
No. Not in the file.
Johnson, right? Yeah. Maybe we should put it in Montalvo.
I don't need it. It's okay. Okay, we can take those if you want. Okay. Hi, this is Judge Sloan. I am ready for Lewis Adams.
You said Angela?
Yeah, I'm Anselone, yeah.
All right, can do.
All right, thank you. Bye.
Yep. Bye.
All right, so now I have a copy of the plea agreement that she would plead guilty as charged to possession of meth, sentence under 7411. Doesn't look like there's any sentencing agreement. So Mr. Sneed, is that a correct recitation of the plea?
Yes, Your Honor.
Okay, and then, all right, Ms. Johnson, you want to raise your right hand for me? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
All right, so I'm going to need you to speak louder. Can you say that again?
Yes.
All right, so Ms. Johnson, you've heard your statement, the statement of the prosecutor, as well as your attorney, and then my recitation of the plea agreement. So is it your intention today to plead guilty as charged to possession of methamphetamine, which carries a maximum penalty of up to 10 years in prison, but under the 7411 status, so if you successfully complete probation and all your terms, it won't remain on your record?
Yes.
Okay,
Yes.
Speak up for me.
Yes.
Okay, are you satisfied with your attorney and the advice that she has given you?
Yes.
All right, neither the prosecutor, the defendant, or anyone on the defendant's behalf has discussed any other possible sentence with the court. Is that correct, Mr. Sneed?
Yes, Your Honor.
And Ms. Damon?
Yes, Your Honor, and it's a no contest plea.
Oh, I'm sorry, it's a no contest. So it's your intention to plead no contest?
Yes. Yes.
Okay. If a guilty or a no contest plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you had been convicted at trial? Do you understand that?
Yes.
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes.
Do you understand that if the plea is accepted and you engage in any misconduct as defined in MCR 6.310 between now and sentencing, the court will not be bound by any sentencing agreement or evaluation. You will not have a right to withdraw your plea. Misconduct is defined to include, but is not limited to, absconding or failing to appear for sentencing, violating terms of condition on bond, or the terms of any sentencing or plea agreement, or otherwise failing to comply with an order of the court pending sentence. So for example, if you were to relapse and start using again, if you were to abscond and not show up for sentencing, then I wouldn't be bound by the 7411 agreement. Do you understand that?
Yes, I do.
Okay. If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I've given to you?
No.
All right, and so we're remembering you're pleading no contest, so your choices would be no contest or not guilty. Do you understand? Okay, so how do you wish to plead to the charge that on or about March 27 of 2025 in the city of Adrian in the county of Lenawee that you did commit the offense of controlled substance possession of methamphetamine? No contest or not guilty?
No contest.
All right, has anyone made any threats or promises to you to induce you to plead guilty or no contest?
No.
All right, do you understand if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
Yes.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead no contest? Mr. Sneed
No, Your Honor.
and Ms. Demont?
No, Your Honor.
Has your attorney promised you any particular sentence or estimated what your sentence will be?
No.
Okay, and it's your own choice to plead no contest? All right, so Mr. Mont, are you going to place factual basis on the record?
Yeah, I can. Let me pull up the report. I have a Lenawee County Sheriff Police Report, CR number 2529690001. The occurrence date and time is March 27th of 2025. Location is Logan Street at South Center Street in Adrian, Michigan. The officer pulled over at the Center Street and Erie Street. He observed a white female who later identified as Noelle Marie Johnson in driver's seat of red Ford Escape, recognized her from prior police contact, had outstanding warrants and no license. When pulled out of the car, there was suspected narcotics located inside of what they indicated was her pink wallet. And the wallet was located inside a larger fabric bag that was in the vehicle that belonged to Noelle. And there is a list indicating that there was methamphetamine in a small plastic bag in that wallet. It was submitted to the lab and came back as a positive and a true narc scan that was positive for methamphetamine.
All right. Are you satisfied with that factual basis, Mr. Sneed?
I am, Your Honor. Thank you.
All right, Ms. Adams, I'm going to need a notice of hearing for October 30 for Ms. Johnson. Thank you. So based on the facts placed on the record and from the information contained in the police report, the court finds beyond a reasonable doubt that on or about March 27 of 2025 in the city of Adrian in the county of Lenawee that Ms. Johnson did have in her possession methamphetamine with no legal right to possess that, and therefore the court accepts the no contest plea based on lack of memory. So has the court complied with MCR 6.302 B, C, and D, Mr. Sneed?
Yes, Your Honor.
And Ms. Demont? Say it again, Ms. Demont, you're kind of breaking up. I just lost her. Hold on. Mr. Fry, do you need a breakout room with Mr. Adams?
If I can take a real quick one, Your Honor.
Yep. So Mr. Adams, while I'm waiting on my other one, I am going to assign you and Mr. Fry to a breakout. You are Mr. Adams in jail Zoom 1, correct?
Yes.
I thought so. All right, go ahead and join that breakout room. All right, Mr. Mott, we got you back. I'm gonna have to have a word with the Hillsdale County Judge about better Wi-Fi there for you. But has court complied with MCR 6.302 B, C, and D, Mr. Mott?
Yes, Your Honor.
Okay, except the plea has been given understandably, voluntarily, and accurately. The defendant has full knowledge of her rights. She does have competent counsel. This court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them other than the Killebrew plea for 7411. I am going to refer this matter to the probation department for a pre-sentence investigation. I am going to set sentencing for October 30th at 8:15 in the morning. Ms. DeMont, so Ms. Johnson, you can appear in person or you can appear via Zoom. What would you prefer?
In person.
In person, so we will set that in person. So have a seat right behind you. Oh, well, hold on a minute. So I'm gonna send you across the hall and you're gonna check in and they're gonna give you a date and time to come meet with the probation department. They'll do a pre-sentence report. Be truthful with them about yourself, your background, what's going on in your life. Obviously, you pled no contest for lack of memory to the offense itself, so you don't have to talk about that. But everything else be truthful about. You'll continue testing once a week now with Mr. Coast.
So what's my color? Like, before I was on colors.
Mr. Coast, she's asking her color.
Yeah,
Like what
and Noelle, I did notify the center, your color has changed from green over to teal.
Teal.
Teal?
Yep,
So
teal,
has
correct.
has teal already dropped this week? Like, do I have to go?
I'm not certain on that. Go ahead and start that up tomorrow.
Okay, so I won't be penalized, so I won't be penalized. No. Already tested this week, because I did test already one time. Green already tested once.
That's fine. Yep, you're not under green anymore. So starting tomorrow, call and your color's now teal.
Okay.
Okay.
All right. Teal.
All right. So we're going to get you a notice of hearing for sentencing on October 30th. And then, like I said, I want you to go over to the probation department. They'll set up a time to talk to you. Make sure you show up for that meeting. Make sure you do everything you're supposed to do for them. They'll prepare a pre-sentence report. We will provide a copy of that to Ms. DeMont. She'll provide you a copy and then review it with you as well. And we'll see you back on October 30th at 8:15. And Ms. Adams, if I can get a notice for Ms. Johnson. So I have a seat right behind you on that bench.
And then last question, so I go get a different time and date from them?
So yeah, they're gonna do a pre-sentence interview with you so that they need an opportunity to sit down and talk to you.
Okay, so
that's one day.
Okay.
And then our sentencing date's another day.
All right,
Okay?
thank you so much.
Uh-huh.
Yeah. I'm due November 14th.
Okay.
Yeah, 30 more weeks.
So if something happens and you can't hear the 30th, let Ms. Dumont know and we'll work with you on that, all right?
Thank you.
You're welcome. Good luck.
Thank you.
All right. And Ms. Adams, you heard me, right?
Yes, and we amended bond, correct?
Say it again.
You amended bond to once per week, is that correct?
Yeah, yeah. Okay, so we're back. Ms. DeMont, did you have anybody else? She's already gone. Somebody gets new. It's Montalvo with Mr. Mont, so let me remind her. So I sent a message to Mr. Mont that we also have Montalvo. All right, Mr. Fry, in the matter of the people of the state of Michigan versus Louis Alfred Adams Jr. We have multiple files, 24 dash, no, yes, 24-21947FH, 24-21948FH, 24-21949FH, 24-22011FH, 24-22012FH, and 25-22337FH. We are set for pretrial on all of these. I have Allison Arnold appearing on behalf of the people, and I have Mr. Fry, you're appearing on all of these, correct?
That's correct, Your Honor.
So I have Brian Fry appearing on behalf of Mr. Adams. So, Mr. Fry, how would you like to proceed today?
Your Honor, we would be asking that file 24-22012FH be scheduled for trial.
So, yeah, just stop across the hall before you leave, all right?
Yeah, thank you.
Okay, I did. All right, so.
It's the home invasion.
Which file, the 22012?
22012. Yep.
Too many twos and too many twos.
So. So these are all felony cases. The lowest file number is 24-21947FH, right?
Yep, Judge, but the home invasion file, if we try that, I think it will resolve all the files. So that's my thought and Mr. Fry's thought.
Okay. So 22012H.
Not that I wouldn't love to have multiple trials with Mr. Fry, but I know the court's busy, so.
Yeah. All right, so 2212, has there been any, and this is just for the record, have there been any plea offers made as a global resolution on these files, just so we can have it on the record?
There has been, Your Honor. The offer, so just so, let me pull this up, just one second. So just so Mr. Adams understands, on this file, if he's convicted of the home invasion first, I show sentencing guideline range on the minimum to be between 87 months and 290 months. So
Well,
pretty
and he has a habitual offender fourth offense notice.
Yeah, that's
so,
with the subs.
Yeah. Well,
So-
all right, so Mr. Adams, you understand that many of these files stack on each other for purposes of sentencing. Do you understand that, Mr. Adams?
Yes.
So if you were to be convicted, say you went to trial on all these files, many of them would stack, so you would serve sentence on one file, then the sentence on another file, and so forth, depending on the charges, depending on if you were on bond, depending on the nature of the offense. So on 24-22012FH, you do have a habitual offender fourth offense notice. So if you were convicted of count 1 and count 2, those are 20-year and 10-year felonies, you would be facing up to life in prison, or the guidelines that Ms. Arnold verbalized with a habitual offender fourth sub. So was there a global plea offered then, Ms. Arnold?
The offer was to plead to count 1 in file 2422011FH and counts 1, 2, and 3 in this file, which Mr. Adams would still have substantial guidelines, but the top would not be 290 months then.
So in this file, the plea would be to plead to count 1 with no subs. Is that what you're saying?
Counts 1, 2, and 3 with no subs.
Right. Yeah, so count 1 would be a 20-year max, count 2 a 10-year, and count 3 would be a 2-year max. but with no habitual offender notice. So his guidelines would be obviously a prison term, but not as substantial as with all of the supplements.
Your Honor, I need help. Like, I'm a drug addict. I need help. I need to see if I can go to the RAP program or some kind of program or something.
So your guidelines are too high for the RAP program, and the RAP program is only used on a violation of probation. We don't send there on an initial sentence. So, you know, unfortunately, you know, that's part of your sentence, but that would be through MDOC because your guidelines will, I mean, obviously be for a prison term, and we can always order drug treatment and programming through MDOC. What about the other files, Ms. Arnold?
All the other stuff would be dismissed. Other
Okay,
than
so
put on the record.
yeah, so Mr. Adams, just to go through it, and I know your attorney's gone through it ad nauseum with you, but we always like to make sure we put it on the record. You have 6 files. The plea offer is to plead on 2 of the files, and on file number 24-22012 FH, it would be pleading guilty to home invasion first degree, which carries a maximum penalty of up to 20 years in prison. Count 2, larceny from the person, that carries a maximum penalty of 10 years, and count 3, R&O, which carries a maximum penalty of up to 2 years, but they would run all together, right?
Yeah,
There's no request. Hold on, Mr. Adams, but Ms. Arnold, there's no request for them to stack it all, correct?
Correct, Judge.
And then on 24-22011 FH, Mr. Adams, the plea offer was plead guilty to count 1, larceny in a building, which carries a maximum penalty of up to 4 years in prison. And that wouldn't stack either. So these sentences would all run together, but your guidelines wouldn't be incredibly high as they would be if you had a habitual offender fourth offense notice. Do you understand that, Mr. Adams?
Yes.
So if you go to trial and you get convicted, then I have to sentence you under the habitual offender notice, which, Ms. Arnold, you said the minimum guidelines were
87, and then guidelines go up to, hang on, sorry, too many tabs here. Guidelines go up to 290 months on the minimum with the habitual offender fourth offense notice. And part of the thing in this file is I've made a plea offer. The only plea discussion I've had has been through the form of correspondence from Mr. Adams where he's requesting no prison. He's been to prison before for larceny offenses, and it's just, we're not going to offer a no prison offer in this case. If there is a counter offer that's reasonable, I would run it by the victims, but there hasn't been one.
So Ms. Arnold, with that, you said it was 87 was the minimum and the max on the home was 290. Is that what you said?
Correct.
For standing in the back of somebody's backyard.
Hold on. So that means if he were to plead, his guidelines would be 87 to 145 without the subs, right?
Correct.
Okay. So
like I said, I would consider a counter offer that involved prison. I would talk to the victims about it, but there hasn't been any counter offer.
Thank you. So Mr. Adams, do you understand the plea offer that's being made now doesn't allow for a no prison term? And RAP is not available to you because this isn't a violation of probation and your guidelines are too high. So Mr. Adams, obviously, you know, this is the reality of what you're looking at. And, you know, I would suggest that, you know, be open in your conversations with Mr. Fry. And
I tell you what, I'll take 3 to 5. I was in somebody's backyard, you know, I wasn't inside their house.
I don't do plea offers. I have nothing to do with plea offers. I just sentence and take the plea. If they're not offering it, you don't get it. But, you know, obviously this is a conversation you need to have with Mr. Fry. So, Mr. Fry, what I would suggest at this point is I'm going to set it out for one more pretrial for you to speak with Mr. Adams and then to speak with Miss Arnold. If it gets resolved, that's fine. If it doesn't, we go to trial. That's fine. I don't mind trials. I enjoy trials. So I'm going to set this out to October 8th. So Mr. Adams, I'll see you back on October 8th at 8:30 in the morning, and at that time, I'll set a trial date, Mr. Fry and Miss Arnold, if we need one. All right?
Okay, thanks, Judge.
Okay.
All right. Thank you, Mr. Adams. You're all set.
Thank you.
Your Honor, do we need to step to adjourn then?
Yep, can you do this in order to adjourn?
I can.
And
move
you can
that.
sign my name.
Thank you.
All right, thank you. All right, so, let's see, Mr. Fry, I think that might be all I had with you. Let me double check. Oh, he's already gone, so it must have been. All right, Mr. Mr. Glazier, I'll take you next. I have one lady that's been here all morning, Taylor Montalvo, so I'll take care of her. Okay, so in the matter of the people of the state of Michigan versus Taylor Rain Montalvo, file number 24-21717 FH. I have Katerina DeMont appearing on behalf of Miss Montalvo. Mr. Mont, I do have a letter from Darren Coast stating that Miss Montalvo has been doing much better staying away from alcohol since she tested positive on August 1 of 25. She has no further positives to report. So that's good, Miss Montalvo. I'm glad to hear that. So, Mr. Mont, how would you like to proceed today?
Your Honor, I have her VOP and her First Circuit Court pretrial date on October 1st. I was wondering if we could set that for that date and time too, and I think we could hopefully have a resolution on each of the three issues.
October 1?
Mhm.
All right. So, Miss Montalvo, I'm going to set this over to October 1 with your other stuff. So we'll see you back on October 1 at 8:30 in the morning. All right, Miss Montalvo?
Okay, thank you.
Thank you. And we'll do the notice on that one because it's about. Thank you, Mr. Mont.
Thank you.
Okay, so you're all set, Miss Montalvo.
Thank you.
All right, Mr. Glazier. All right, Mr. Bowers, you want to come up to the podium? All right, so this is in the matter of people of the state of Michigan versus Gregory Allen Bowers, file number 25-22231 FH. I have John Glazier appearing on behalf of Mr. Bowers. Mr. Bowers is present in the courtroom, and I have Dan Gumtow from the prosecutor's office. So, Mr. Glazier, this is date and time set for a pretrial conference in this matter. Mr. Bowers, did you go get your fingerprints done?
I didn't know I was supposed to. I never.
Okay. So, this is an MSP case. Do you think I can get him to do them at the sheriff's?
I don't know.
All right, so Miss Adams, can we print off a copy of the order for fingerprints?
Okay.
So you're gonna have to get a hold of the Michigan State Police to get this done.
Okay.
And perhaps Mr. Glazier can assist you with that, but you're gonna need to get your fingerprints done and yeah. I don't know why they don't check this. All right, so Mr. Glazier, how would you like to proceed today? You're muted, Mr. Glazier.
We adjourned this for a couple of reasons. One was that the plea agreement was to indicate no upfront jail, and that is reflected on there now, Killebrew, no upfront jail. The other issue was, Your Honor, that the amended information says fourth offense notice. It should say second offense notice. There's only one conviction showing under there, I think.
So the amended information does add a count 4 habitual offender fourth offense notice. Yeah, so Mr. Gumto.
Your Honor, I would argue that it's irrelevant because in the plea deal, we are dismissing, any of the.
I appreciate that, Mr. Gumto, but I always think it's important that they accurately reflect the status just because it's used by the probation department and perhaps in other cases. So if we could just get an amended felony information with the correct offense notice.
Actually, I think it's third offense. It looks like they're listing 2 under there.
That was also, I didn't think that was second was appropriate. So it's a third, you agree, John?
Yeah, I think it's a third. I think looking at it now, you show 2 under it. And so it'd be a third and you're showing it as a fourth.
I can amend that and have that to the court this morning.
Okay, why does it have? So, it also, I just noticed it has count 1, possession of meth, count 4, habitual offender fourth offense notice, and count 2. So they need to, I don't know what happened. I don't.
I didn't even notice it. There should be a added count of possession of cocaine.
It is, but it's added under the sub as count 2. So they probably, whoever does that, Mr. Gumto, probably needs to clean that up. All right. So is the plea agreement, he's going to plead guilty to count 2, controlled substance possession of cocaine, which carries a maximum penalty of up to 4 years in prison. Is that correct, Mr. Glazier?
That's correct, Your Honor.
And Mr. Gumto?
And the supplemental be dismissed.
Right, and no sub. Is that correct, Mr. Gumto?
Yes, Your Honor.
All right, and Mr. Bowers, you did sign an advice of rights form and you got to read through that, right?
Yes.
Okay, thank you.
Please, good job.
Okay, Mr. Bowers, raise your right hand.
Am I pleading today?
Is he pleading today, Mr. Glazier?
That's what I thought. You don't want to take that deal?
I remember when we watched the video, I want to get the analysis of it because he changed it.
Okay, so he doesn't want to plead today. So I'm gonna
turn it out. Then he can come in and see me.
Yep. So Ms. Adams, I'm gonna need a notice of hearing for October 22nd. So I'm gonna set this out to October 22nd at 8:30 in the morning for a pretrial. And we'll do the notice of hearing because he's here. So Mr. Bowers, have a seat behind you.
October what?
22nd at 8:30 in the morning.
Mr. Bowers, you got to come in and see me, set up an appointment to see me before that day.
Okay, all right. So you have a seat right there. We'll get you a notice of hearing. All right, so arraignment was waived in the matter of Nathan Lawrence, file number 25-22395FH. Arraignment was waived in the matter of Deshaun Mitchell, file number 25-22397FH. So now, Mr. Glazier, Mr. Malaro was covering for Mr. Murphy, I believe, on Erica Wright. And I think that's all I have left. And then I have a couple pickups, which I need Rhonda on. So what are you here for?
I'm done.
Just observing? Okay. So I'm waiting for Mr. Malaro for you and Miss Underwood for you. And that's it. Okay, so I'm going to take a recess until we get Mr. Malaro or Miss Underwood. So you don't leave the floor. You guys can take a break and use the restroom if you want, but don't leave the floor. Okay.
Good morning. How are you? Good. Doing okay. Thanks. Good to see you. Yes, sir.
Today, here, is there a way I could verify that?
Hold on one second, okay?
Yes, ma'am.
But then there might be- I'll check. So that's all. I'm so sorry. I'm so sorry. Okay, thank you, sir. Yes. Okay, yeah, no, I don't, let me go check, okay? She feels like a seizure going on. Okay. Do you wanna go to her? Then she said, oh. No. Sorry, she says that she feels like she's got a seizure coming on,
Okay.
so she has to take
Erica's gotta
meds.
stay, but
Exactly, but the mom can go get the medicine, but she's gotta stay.
Join them going downstairs with security, know that they can bring it in.
Okay, okay.
some reason they don't allow them to bring medication in. So I told them to let it in.
Oh, okay. Yeah, that doesn't, I mean, that typically I understand that. I mean,
Well,
you
if
know,
if it's in the prescription bottle, I mean, it's. Yeah, I don't.
I don't know.
It's not my rules.
Nope, not
But
me.
like I say, just,
Mine either, but I can understand that. But I don't know.
yeah.
I mean, think about what we're dealing with too, you
Right.
know?
See, a lot of times probation wants them to bring the medicine in.
Right.
So they can see what they
Right,
got. So
right,
they have to leave it in front and probation got to go down.
right, yeah,
Now I told them, let her bring it in up here.
yeah.
I need, Mr. Likens.
Okay.
He might be in the hallway. Miss Underwood, you are way too busy. I think that you have way too many cases.
Your Honor, I just, I don't
Disagree.
take any time. I'm
No,
here.
I'm not complaining, Miss Underwood. I'm saying I think you're the busiest attorney we have, is what I'm saying.
Well, that may well be.
Okay. All right, I'm gonna call the jail. No, I gotta call booking. Hold on, Mr. Likens. Okay. Hey, this is Judge Ann Sloan. I am ready for Dylan Scott again. I have an attorney.
Oh, you're for Dylan Scott? Okay, give me just a minute and I will find a place for her.
All right, thank you.
Here.
All right. Grab his files. All right, we are back on the record in the matter of the people of the state of Michigan versus Benjamin V. Likens. So, Mr. Likens, when we were here, you had asked for court-appointed counsel. We've appointed Miss Underwood to represent you. So, Miss Underwood, would you like a breakout room with Mr. Likens?
Yes, please.
All right. So, my bailiff's going to take you out to the Zoom device in the hallway. Okay. And then I'll put you in a breakout room with Miss Underwood. All right, so I'm gonna let him in, Miss Underwood, and put you in a breakout room. Okay, good job, Mr. Likens and Deputy. So I am going to assign the hallway and Miss Underwood to a breakout room. Go ahead and join that breakout room.
This is tomorrow. Okay, clear.
Thank you.
We have one down here. Susan down here. She has some medical issues. We're getting some.
To bring in her medication.
Yeah. Thank you. Seems to be Dr. Ray.
Find it back here. Mr. Malaro, if you want to go in the hallway, you can. She did test positive for cocaine, I believe.
Okay.
No. All right, so,
Are we on the record, Judge?
I'm just gonna, Mr. Scott,
Yes,
your
ma'am.
attorney's here. She's talking to somebody else, and just be a minute. All right. And then I'll have her talk to you.
Yes, ma'am.
Yeah, you can come back in. All right, Miss Underwood, I have Mr. Lyens back.
Thank
So,
you.
you're welcome, Miss Underwood. How would you like to proceed?
Your Honor, we would ask the court to continue the not guilty plea. Mr. Lyens has proof of employment. Mr. Lyens did 90 days, Your Honor, because he was approved for outpatient treatment and not approved for inpatient treatment. So he did the full 90 days. Since he's got out, he's made money. He doesn't owe much to this court. I'm at a loss to see why this is an issue.
So I will set this over to October 22nd at 8:30. Miss Adams, could I get a notice of hearing from Mr. Lyens? Okay. So we'll get you a notice of hearing. So just have a seat behind you, okay?
Give this to the clerk. It's just a.
Give that to your PO. Is that proof of employment?
It's my sole proprietorship paperwork, my DBA.
Yeah. Okay. All right. Okay. So now I have Mr. Scott, Miss Underwood. So in the matter of the people of the state of Michigan versus Dylan Matthew Scott, Miss Underwood, this is a bench warrant from 2023. So it obviously is a non-technical now. So I'm going to open up that breakout room. And one second. All right, there we go. So I'm going to open up the breakout room for you and Mr. Scott. Go ahead and join that breakout room.
You said join it?
Yes, sir.
Yes, ma'am.
You ready, Mr. Malone?
Think so.
Okay, so, Miss Adams, I might have sent the right file back. Nope, I found it. Never mind. So this is in the matter of the people of the state of Michigan versus Erica Lynn Wright. File number 25-22217FH. I have Salvatore Malaro appearing on behalf of Ms. Wright, Mr. Sneed appearing on behalf of the people. So Mr. Malaro, Ms. Wright hasn't, again, we had a show cause. Ms. Wright hasn't done her drug screen since August 15. She claims her doctor told her she couldn't leave the house. She did provide documentation from her doctor, but it mentioned nothing about travel restrictions. We had a report in person today. We did have a drug test done and tested positive for marijuana and cocaine. Is that what it was, Mr. Coast?
It is, Judge, of THC and also cocaine.
So she tested positive for THC and cocaine. So Mr. Malaro, you know, in this case, we have had a history of non-compliance, failure to appears. She did turn herself in the warrant, but then she failed to appear again, and then failure to drug test, and then now testing positive for marijuana and cocaine. Are you here on right?
No.
Okay, so Mr. Malaro, I know you are covering this for Mr. Murphy, but how would you like to proceed today on the contempt of court?
So, Judge, I'd like to adjourn these for Mr. Murphy. By my initial understanding is this is going to be a plea. Ms. Wright's indicated to me she'd be more comfortable with Mr. Murphy. As to the court's statement about traveling, in my brief glance at an after visit summary from June of this year, talks about her having seizures, and it says, important notice for patients traveling to Michigan. Madison University of Michigan. And it also talks about the law in the state of Michigan, talks about people who have episodes.
Well, she had somebody drive her today, so.
And I'm not familiar with the case, Your Honor.
I gave, Mr. Coates.
So I also have concerns with health conditions and cocaine usage and marijuana usage.
That's my next issue, Judge. Ms. Wright has provided me with a whole list of medications she's on. And without time to review them, to see if there's any possibility of a false positive, I would be unprepared to address that issue, but I think Mr. Murphy would be. So I'd ask to adjourn this. Clearly, he has serious health issues if he's taking any of these things without doctor supervision. That would be bad. I'm pretty sure she's aware of that. So at first glance, I would be surprised. So I would ask to adjourn this and perhaps allow Ms. Wright to talk to Mr. Murphy to get to the bottom of this.
Okay, Mr. Coast, was it a urine sample we had done today?
Judge, it was a urine sample. I do want to point out that we did do a swab back in April, and that April swab was also positive for THC and cocaine.
Okay, all right. All right, okay, so I'm going to have Mr. Coast do a show pause for contempt of court, and then we'll get another date on that for.
He's back next week, I think.
Okay, so Mr. Coast, if you can do that show pause, and Miss Adams, could I set that over to next week, Miss Adams?
Are you talking about next Wednesday?
Yeah, September 24th, is that all right?
Yes, that works.
All right, so can I get a notice of hearing for her for the pretrial and contempt of court?
Yes.
Okay, so Ms. Wright, again, I want you to come in person. Mr. Coast, how is she supposed to be testing?
Judge, she was actually supposed to be doing swabs with me 2 times a week. But again, I haven't received or haven't done a drug screen on her for a month. So I like to obviously continue to do the swabs here at the courthouse. But I will get her a notice this morning for her to appear on that contempt of court for next Wednesday.
All right, so you are still required to test twice a week with Mr. Coast.
Thank you, Judge.
And Mr. Coast will meet with you in the hallway. We'll get you a notice of hearing for next week. And then you'll obviously make sure you reach out to Mr. Murphy, to investigate whatever your claims are about perhaps, but, marijuana tends to not be something that is a false positive for some other medication. So, you will follow the instruction of Mr. Coast. If you don't report, then understand I will keep you at the jail where I know where you are. All right. We'll see you back next week. I'll enter, we have not,
Thank you, Judge.
we have not told you. Thank you. All right, Miss Underwood, let me see. I think I got your client in the lockup. Hold on.
Can I go speak to him, Judge?
Oh, go speak to him.
He wants to talk to his
That
client.
guy? Okay.
Yeah, that guy.
Yeah, you can go talk to that guy. All right, Miss Underwood, hold on. I'm closing the jail room.
85-20.
All right, Miss Underwood, we are back with Mr. Scott. So, Miss Underwood, how would you like to proceed with Mr. Scott?
I believe, Your Honor, Mr. Scott would like to enter a plea to the violation, Your Honor, and then I would like to discuss further proceedings.
Okay, so Mr. Scott, you want to raise your right hand for me? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, so you are Dylan Matthew Scott, correct?
Yes, ma'am.
All right, so Mr. Scott, I did review your request and warrant for probation violation for failure to report as instructed on or about August 5 of 2022 or any time thereafter, and that you were on probation for child support failure to pay. Miss Adams, I think we need to call down to friend of the court too, do we not?
Yes.
I'm sorry. So I think this is Kelly Cam. Do you want to call her? Or you want me to?
I believe Mr. Scott has been making payments, Your Honor.
Hold on, Miss Underwood. Hold on. No, I don't, that's fine, but making payments is one thing and showing up is another, so we'll talk about it. So I had to call, we're calling for the front of the court caseworker. So, Mr. Scott, if you plead guilty on the violation of probation, you understand the maximum penalty can be up to 4 years in prison. Your arrearage has gone up since January. So in January of 25, your arrearage was $4,386. As of today, it's $7,324. So if he's been making payments, he hasn't been making much. So this is your third show cause. So on the contempt court, failure to appear and failure to pay child support, that carries a maximum penalty of up to 90 days in jail. And on the violation of probation, if you plead guilty or found guilty, you could be facing up to 4 years in prison. Do you understand that, Mr. Scott?
Yes, ma'am.
Okay, now you would ask for court-appointed counsel. We appointed Ms. Underwood to represent you. Have you had ample time to speak with Ms. Underwood?
Yes, ma'am.
Are you satisfied with Ms. Underwood as your attorney and the advice that she has given you?
Yes, ma'am.
All right, and Ms. Underwood is going to plead guilty on the front of the court show cause and failure to appear, as well as the felony violation of probation. Is that correct, Ms. Underwood?
That's correct, Your Honor.
All right, excellent. So, Mr. Scott, do you understand that you have a right, hold on, let me let the front of the court in. You have a right to contest the violation of probation charge as well as the front of the court show causes and to have a hearing on them or a trial on them. Do you understand that?
Yes, ma'am.
Do you understand that throughout the trial, you would be presumed innocent until your guilt is proven by a preponderance of the evidence? Do you understand that?
Yes, ma'am.
You have a right to have all the witnesses against you appear at your trial, to have your lawyer ask those witnesses questions, or you may ask them yourself, and to have me order any witnesses you might have to appear at the trial. Do you understand all of that?
Yes, ma'am.
All right. You do not have to testify at your trial, and no one can say anything about you not testifying or hold it against you in any way. Do you understand all of that?
Yes, ma'am.
On the other hand, do you understand that you have a right to testify at your trial if you want to testify?
Yes, ma'am.
All right, so we're gonna start on the violation of probation file number 22-20799FH. So Mr. Scott, how do you plead to the charge that you violated the terms of your probation and that you failed to report on August 5 of 2022 or any time thereafter? Guilty or not guilty?
Guilty, ma'am.
All right, and then on the front of the court show cause, how do you plead to the charge that you violated how do you plead to the charge that you failed to pay child support up to the amount ordered in that file? Guilty or not guilty?
Guilty, ma'am.
And then how do you plead to the charge that you failed to appear for a court date on your front of the court show cause on March 6 of 2023? Guilty or not guilty?
Guilty, ma'am.
All right. Has anyone threatened you in any way to get you to plead guilty?
No, ma'am.
Has anybody promised you anything to get you to plead guilty?
No, ma'am.
Do you understand that by pleading guilty, you'll be giving up your right to a trial as we've already explained to you?
Yes, ma'am.
If I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea. Do you understand that?
Yes, ma'am.
Is it your own choice to plead guilty?
Yes, ma'am.
All right, so Mr. Scott, let's go back to the felony file on file number 22-20799FH. You were placed on probation for a felony child support failure to pay case. And one of the terms of your probation is that you were ordered to report as required. Is that correct?
Yes, ma'am.
Now, you were supposed to report to probation back on August 5 of 2022, and you failed to report that day. Is that correct?
Yes, ma'am.
And you failed to report any day after. Is that correct?
Yes, ma'am.
All right. And then on your front of the court show cause, you were ordered to pay $111 a month in child support. Is that correct?
I believe so. I've never seen my paperwork for child support. I've never seen it.
Did you ever come to the courthouse and ask for a copy of it?
No, ma'am. I know that it's one something a month. I've only been paying for a couple months, about 9 months, I think. I've been paying $100.
Mr. Scott, the question was, you were ordered to pay $111.
Yes,
would you agree that's probably correct?
Yes, ma'am. Yes, ma'am.
And if you don't know it, it's because you never came here and got your paperwork to
Yes,
find
ma'am.
out what you were ordered to pay, correct?
Yes, ma'am.
But I'm gonna guess somewhere in the last prior show causes or in the felony case, you were told what you were ordered to pay. Is that correct?
Yes, ma'am. Yeah, yes, ma'am.
Okay, so were you paying $111 every month as you were required to do?
No, ma'am.
Okay, and all right, and then you were ordered to appear for that show cause on March 6th of 2023. Did you appear for that hearing?
No, ma'am.
Okay, all right. I accept the pleas. They've been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. I am going to refer this matter to the probation department for a pre-sentence investigation. Ms. Underwood, sentencing would be September 25 at 8 a.m. Are you available that day?
That's fine.
All right, so we'll set it for sentencing September 25 at 8 a.m. So before you ask anything else, Ms. Senkowitz, do we have a history of payments on this recently on the front of the court show cause?
Yes, anywhere between $9 and $18 and change for the last, I don't know, 4 to 6 months.
A month?
Yes.
I've been paying
Okay.
every 2 weeks. Every 2 weeks I've been paying.
How many child support cases do you have?
I have 2, but it's all one. All with the same lady.
But Ms. Underwood, at the end of the day, the bigger concern is the absconding from probation on the felony case. So I will set this over to September 25 at 8 a.m. Mr. Scott, do you want to appear in person or via Zoom for sentencing?
Via Zoom, I guess. Zoom.
Okay.
So can we have another date, either the day before or after that, possibly?
Ms. Adams, can I do Wednesday?
Yeah, we could do the 24th at 8.
We'll do September 24 at 8 AM. So we'll see you back next Wednesday at 8 AM. Someone from the probation department will be over to meet with you and they'll do an updated pre-sentence report. And then we will see you back that day on sentencing on both of these. Thank you.
Yes, ma'am.
Thank
Actually,
you.
I already
Thank you.
talked to him yesterday, so I won't be seeing him, just so he knows.
Oh, okay. All right. Thank you all.
Thank you, Your Honor. Your Honor.
I'm good to go, ma'am.
Yep, you are free to go.
Yes, ma'am.
I believe that concludes my docket with you.
All right. Thank you,
Bye.
Miss Underwood. All right. And let me stop live stream for closed hearing.